Welcome to the Business Owners Council, Legal Issues from Growth to Exit.
Welcome back to the Business Owners Council, Legal Issues from Growth to Exit. I'm Shameika Rhymes, and in each episode, we sit down with Kevin Brick, founder of Brick Business Law and trusted advisor to Florida companies, to talk through the strategies business owners need to grow, protect, and maximize the value of their businesses. Today, we're talking about how to hire the right lawyer and build a strong litigation strategy after your business has been sued. Hi, Kevin.
Hi, how are you?
Doing well. How are you?
Good, thanks.
Well, we got to talk about how to choose the right lawyer. So, what should business owners look for in a litigation firm?
Yeah, if you've been sued and you're looking for a law firm or a lawyer to help you with the lawsuit, I would say most important probably is just relevant, specific experience regarding the type of litigation it is. So, employment litigation is different than consumer, is different than real estate. And I would say you want to make sure you got somebody who is dialed into that specific area of the law. In general, I like to have, if I'm selecting an attorney, I would say it's somebody who's a good strategic thinker. We don't want somebody that's just reacting to what the other side does, but has a plan and is executing it. And then, as we're thinking on this podcast about business owners in particular, you really want somebody who's going to understand your position and align with you on the goals, the budget, the approach, all of those things. If you think about it, this is somebody who you may work with for 2 years. That's how, a lot of lawsuits last a long time. And you've got to really be able to be on the right page with them in terms of personality and how they work.
What are the biggest mistakes when hiring a lawyer?
Um, there's a couple things. One is, choosing just based on pricing. That's, I think you end up that not being a good approach. Number two, this goes back to kind of what I said in the last answer, is you don't really want to hire a generalist for litigation. You want somebody who specializes in that practice area. Another one, just not asking about and deciding on strategy up front. Some attorneys, their strategy is the same every time, and that they don't adapt it to a particular case or style or personal preference, and that's something that can be an issue. Another one is ignoring communication style. Some people, they want to come in the office. Some people, they only want to do email. And that becomes important over a long period of time of trying to work with somebody. And then the last one, in terms of a mistake I would see often, is just waiting too long to engage. Sometimes you put your attorney kind of behind the eight ball if you're coming in and your case is a fire drill. So try to get ahead of it as fast as you can.
Well, what questions should you be asking before hiring a firm? I know you mentioned, see if they're um, in specializing in that same industry.
Yeah, so if you do meet with somebody who's a specialist and you bring in a case, for instance, you've been sued or you have a claim, the person should have a good view, a well-informed view of the case at the outset. They should be able to understand the issues and think through the strategy. So asking them what's their view of the case, asking them what are the potential outcomes, what are the risks and opportunities, ask them, how do they like to approach, say, an early resolution versus litigating until trial. And then another piece of it, just in terms of the nuts and bolts of the case and how they handle it, is who is going to be the actual person in the firm handling the case. Because a lot of times you might meet with a partner, but it's really an associate that's doing most of the work. So those are big picture things you should ask at the outset. Their view of the case, how it's going to progress, what are the risks? All those things make a lot of sense in the initial interview process.
Well, you mentioned strategy. So, how should you evaluate litigation strategy early?
Well, when we're talking about the business as the client, right? There's the normal things of risks and cost. So you're going to benefit. What are the risks of pushing it forward, of settling, of not settling? How much is it going to cost to carry it to that point? But also for a business, you got to think about what's the impact on the business. So, for instance, I had a lawsuit one time that the other side was deposing all of our employees, and it was very disruptive. And so, if you're the business owner, you have to understand it's not maybe just about the spend of, paying your attorney, but there also might be a business impact to continuing on in litigation. Um, there's a thought process, a spectrum of thought about, you know, settlement, early settlement, pushing for settlement versus preparing a case all the way through to fight to the end. And so, that's certainly a consideration when you're looking at early strategy. And then I would say figuring out the timing and leverage points of the case, when you're going to pull certain levers, what makes sense to do it when. Those are all just pieces of that early business decision about how you're going to pursue the case.
What are some different paths that a case can take?
Well, when a case is first filed, um, and the other side is served and gets involved, there could be an early dismissal of the case, or procedural issues that cause the case to go away, or it could be informally negotiated and a resolution reached. Or as it progresses, if it does progress, it could go to a formal mediation. It could be resolved in what's called a summary judgment process, where the judge decides it just based on the law. Or it could go, as you picture the full trial, where the case, you have witnesses and things presented, and a final judgment is issued at that point. And I think each of those, depending on what type of outcome you're pushing for and when, each of those outcomes requires a unique strategy to push towards.
Mhm. Did both of those kind of take about the same amount of time? I know you mentioned 2 years is the average length of time.
Well, no, they're all across the board. So sometimes a mediation could be early. Um, some cases that are complex, it's many, many years, and some cases can get pushed pretty quickly. In Florida here, there's cases get put on particular schedules of when things should occur, and so some are shorter and some are longer. Complex business litigation can take a long time, and then you think about it settling or resolving at different stages. That also can significantly affect the amount of time it takes.
Okay. Well, how should business owners think about cost? I know we touched on it a little bit, but how should they think about it when deciding, like, okay, I'm going to go find the right lawyer, the right firm for us to handle this?
Well, the big potential outlays in terms of cost are paying for your attorneys, and then liability exposure, having to pay a judgment, or even having to pay the other side's attorney's fees if you lose, and there's a claim or an ability for them to recover. So you've got, the ongoing costs, and then at the end, potential to have to pay for something. There's also other costs like distraction I mentioned of your business employees, things that divert your attention away from running your business. So a lot of times a lawsuit requires input and time and effort from executive level people or employees, and that takes a real toll on a business, especially if a lawsuit goes on for a long time. And then there's the cost of setting a bad precedent. For instance, if you have a non compete clause in your employment agreements, and you have hundreds of employees that signed it, and you go to litigation, and the court finds that it's not an effective provision. Well, now you've created a pretty bad precedent for, potentially trying to enforce it against all of your other employees who may go and do something. So there's a cost of setting a bad precedent in court too. So you got to think about all those things from a strategic standpoint of what makes sense to push and how much it's going to cost.
What makes a strong litigation plan?
Well, having a plan is great. A lot of people don't, they go in without a plan. So I would say at the outset, you want to have clear objectives of what a win is. Are you trying to make this last a long time, make it very painful for the other side? Are you trying to win money? Are you trying to preserve relationships? Or what is the objective of the lawsuit? And then you want to define strategy that's based on those objectives. Try to set some budget expectations around the tasks that need to be done, then make sure that there is a good communication plan between the members of the legal team and the business itself. I think if you've got those elements in a litigation plan, you're likely to be successful.
Okay. Well, how important is early case assessment?
So assessing a case early is really important because number one, it just sets expectations. Having misaligned expectations is a major problem, especially if you're a year or two into expensive, stressful litigation. So at the front end, you got to make sure that you have realistic expectations. And another piece of it is identifying where are the leverage points in the case, right? That means where is the other side weak? Where is yours strong? It's looking at the applicable law the parties themselves, the strength of testimony and witnesses, the budget that the other side has. So understanding where your leverage points are, where your strengths are, and then trying to find a way to be very efficient, like not wasting time, wasting money, wasting mental effort. I think those, if you can assess the case early, I think those are three big wins you can bring out of it.
Okay. What role does documentation play in your defense?
So if you're a business that's defending against a lawsuit and you have documentation of things, um, that is evidence that it can support your argument and your positions in a case. It can also serve to undermine opposing claims or defenses, and then ultimately that improves your settlement leverage and improves your potential outcomes. So if you've got documentation of business policies or communications or different things that are supportive of your organization, they can serve a very important role in the lawsuit.
Well, how should you think about settlement versus fighting?
Yeah, for a business, you got to think about number one, how is fighting versus settlement going to affect your business? And we talked about disruption, mental energy, people being pulled out, costs, money coming out of the business for this instead of reinvesting it. So the business impact is one big thing. Another one is the strength of the argument, uh, the strength of your evidence, the strength of your case. Are you likely to win if you fight it versus settle in? And then really, you have to balance, what's more important to you, the cost versus the outcome, and look at it like a business decision. What is the return of investment in time and in money on the litigation? If it's likely positive, maybe you continue. But if it gets negative, the further it goes, I think you look more at earlier settlement.
Okay. What would you say are the biggest communication mistakes with your lawyer?
Well, I would say number one is not being transparent with your lawyer about the case, the evidence, the facts. Number two is delaying responses, not being as responsive as you could be. And number three, similarly, just withholding the bad facts. A lot of people, when they go consult with an attorney, they're kind of trying to sell their case to the attorney. Oh, this is such a great case. But really, just being honest and straightforward about the good and the bad facts is what makes the relationship more likely to be successful.
Okay. So let's say the business decides to hire a lawyer. How should that lawyer and the business owner work together?
Well, you need to have clear roles and expectations of how you're going to work together. So we're talking about where is there going to be handoffs in responsibility? Um, what is the communication cadence you want to have? I would say having regular updates is really important. And that's not just from the lawyer or the law firm to explain what's going on with the case, but also the business owner or the business executive needs to be keeping the lawyer and the law firm up to date on things that might be changing in terms of strategy or financial strength or things that might affect the way that the case is being pushed forward. And then just making sure you have one thing I've alluded to before is alignment on goals. So starting out aligned and then continuing to have checkpoints during the course of the litigation to make sure you're staying aligned.
That's great advice. What does a well run case feel like from the client's perspective?
On the client side, you should know what's happening with your case. You should understand what the options are. You should understand what the risks are. Um, I I think what it does not mean is that you're winning every argument in every hearing. So a lot of the times, there's going to be some losses on the way to an overall win. Another thing is it doesn't, everything shouldn't go necessarily smoothly, even if it's being well run. Sometimes if your side is running a case really well, you've got a strong case, the other side is going to be misbehaving, trying to throw bombs in the way, trying to delay and make it more difficult. So you should expect that is going to happen, even if your side is running a well-run case.
What would you say are the biggest pitfalls during litigation?
The biggest pitfalls, emotional decision making, changing strategies. Well, changing strategies, but it's good to update your strategy based on new information and new discoveries, how things look as you proceed, but you don't want to be inconsistent. You want to you want to continue to look at things through the same lens as you started with, if possible. Um, Poor communication is another big pitfall. Over or underspending on certain stages of the case. You can't always right size every stage and all the spending because some of it, you got to respond to what the other side's doing. But there's some level of things that you can and can't or should not do within certain budget levels. And so I would say, that becomes a pitfall if you're spending too much or too little in various places.
On the flip side, what does success actually look like in litigation?
Well, for business litigation, it's not really as black and white as winning an injury lawsuit or something where you can kind of clearly say we won this much money. A lot of times the client's goals in business relationships there's a variety of outcomes. Sometimes it's about preserving reputation. Sometimes it's about actually winning the money. Sometimes it's about delaying and delaying until a certain outcome is reached. But ultimately, you want to make sure, if you're successful, that the risks have been contained, the business has been protected, and whatever resolution you're working towards, that you've done it efficiently.
So, as we wrap up, what should business owners do right now if they're facing a lawsuit?
I mean, the basic things are get the right legal team in place, understand what your options are, and then build out a clear case strategy at the early stages.
Great advice. Thank you, Kevin. This has been such an informative episode.
Thanks for having me.
Well, that's it for today's episode of the Business Owners Council Legal Issues from Growth to Exit. If your company is facing litigation and evaluating legal strategy, you can learn more about Kevin Brick and the team at Brick Business Law by visiting brickbusinesslaw.com. If you found this episode helpful, be sure to like, leave a review, and subscribe to the show so you don't miss the next episode.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.